Good afternoon, everybody, and welcome to the press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. This is the first press briefing after the court's summer recess and covers the period from 25th July until today. In the trial of Hashim Thaçi, Kadri Veseli, Jakub Krasniqi, and Recep Selimi, the trial panel on 25th July denied a request by the defense teams for disclosure of further information on an assistant prosecutor who previously worked in the detention facility of the Specialist Chambers. The defense had raised concerns regarding a potential conflict of interest, suspecting that the person in question may have had access to privileged information at the detention management unit. The panel found that the registrar, as well as the prosecution, had already provided the defense with detailed information on the prior employment and specific role of the person, as well as on steps taken to prevent a conflict of interest. On 25th July, a decision issued in May of this year concerning a prosecution request for admission of evidence was made public. The panel granted the motion in part, while also denying the admission into evidence of some exhibits, because the prosecution could not demonstrate good cause for why the request was not made earlier, and because the exhibits lacked authenticity. In its decision, the panel highlighted that the defense will be able to make submissions on the admitted exhibits in respect of their weight and probative value, and to challenge their content. Whether or not the panel will rely on the admitted evidence in the judgment and how much weight it may attach to it is a matter to be decided by the judges when they assess all the admitted evidence at the end of the case. On 11th August, the trial panel granted in part a request by the Thaçi defense to appeal a decision by the trial panel. After the testimony of a prosecution witness, the defense had asked to tender into evidence prior statements of the same witness. The panel at that time rejected the request and instructed the Thaçi defense to tender the statements at a later stage. However, when they then made the request as suggested, the panel rejected their request, finding that the statements should be tendered under the specific rules for written witness statements. In this context, the Thaçi defense asked for permission to appeal the decision based on the question of whether statements tendered during cross-examination really have to be tendered under the specific rules on written witness statements, whether the trial panel erred in finding that the request was made too late, and whether the defense can, as advised by the panel, tender the statements as their own evidence, considering that they cannot call a witness that has already testified in the prosecution case. The panel granted the Thaçi defense permission to appeal the first issue, namely the question if statements tendered during cross-examination need to fulfill the requirements for written witness statements. The panel found that it would significantly affect the fair and expeditious conduct of the proceedings, and a resolution of the issue would materially advance the proceedings. Specialist Chambers President Ekaterina Trendafilova on 14th August assigned a Court of Appeals panel consisting of judges Michel Picard, Kai Ambos, and Nina Jørgensen. On 11th August, the trial panel ordered the continued detention of Mr. Thaçi, finding that the risks that he may obstruct the progress of proceedings and/or commit further crimes continue to exist. The panel highlighted that these risks exist even after the prosecution has closed its case, as many of the witnesses are under protective measures and their identities could not become known to the public at any time. In addition, the risk of interference also includes any attempt to retaliate against witnesses who have testified, as well as attempts to interfere with witnesses in parallel proceedings. The panel also recalled that it appears that Mr. Thatchi provided non-privileged visitors with information elicited during the testimony of protected witnesses, and that the record suggests that he passed on instructions pertaining to the form and content of the testimony of a witness called by the prosecution. As such, the panel considered that the release of Mr. Thatchi with sensitive information in his possession would not be conducive to the effective protection of witnesses. On 13th August, the appeals panel denied the appeals by Recep Selimi, Kadri Veseli, and Jakub Krasniqi, challenging the trial panel's decision on their requests for conditional release. For all three defendants, the appeals panel confirmed the trial panel's findings that there continues to be a risk that the accused may obstruct the progress of proceedings and commit further crimes even after the prosecution has closed its case, considering that they may retaliate against witnesses who have testified, attempt to incentivize witnesses to recant their testimony, or attempt to interfere with witnesses in parallel proceedings. The appeals panel considered that it was reasonable for the trial panel to be mindful of the climate of witness interference prevailing in Kosovo. Regarding Recep Selimi and Kadri Veseli, the appeals panel further considered the allegation that the accused disclosed confidential information to unauthorized third parties in the detention facilities. On 19th August, the trial panel, during a defense preparation conference, set the date for the start of the presentation of the defense case for 15th September 2025. During the hearing, the parties discussed pending matters such as time estimates for witness testimonies, the order in which witnesses are to be called, the disclosure of witness statements, and the number of exhibits and evidentiary documents the defense intends to present. The schedule of hearings until December has been published on the KSC website. The next hearing in this case is scheduled on 15th September, starting at 9 in the morning. In the case of Hashim Thatchi, Bashkim Smakai, Fadil Fazliu, Izni Kilay, and Hayreddin Kuchi, the pretrial judge on 24th July rejected requests by Mr. Thatchi and Mr. Fazliu to appeal the pretrial judge's decision on preliminary motions alleging defects in the indictment. The two defense teams had argued that the prosecution had not provided sufficient details in support of the charge of attempted obstruction. The pretrial judge found that the arguments of the defense were not appealable issues, as they misrepresented the pretrial judge's decision and simply disagreed with it. In another decision from 25th July on the next steps in this case, the pretrial judge took note of the advanced stage of the disclosure process and ordered the prosecution to provide her with information regarding remaining disclosure obligations and when the prosecution intends to be ready for trial by 25th August. The pretrial judge ordered the defense teams to provide her with information on whether they intend to conduct investigations or seek further forensic analysis, whether they object to any of the evidence disclosed by the prosecution, and when they foresee being ready for trial. The pretrial judge set 19th September as the deadline for the prosecution to file its pretrial brief, and 20th October as deadline for the defense to file its brief. On 25th July, Specialist Chambers President Ekaterina Trandafilova assigned a Court of Appeals panel to review decisions challenged by the Thatchi defense on how adjudicated facts in the war crimes case will apply to the current case, if the pretrial judge should have reviewed the legality of her own assignments as pretrial and single judge, and whether the defense should be allowed to challenge, through a preliminary motion, the practice of appointing the same judge as single judge and pretrial judge. The appeals panels both consist of judges Michel Picard, Emilio Gatti, and Nina Jørgensen. When asking permission to appeal the two decisions, the Thaçi defense had also asked for an extension of time to file the appeals, arguing that these raise significant issues which implicate the fundamental rights of the accused. In addition, the defense claimed that the deadline falls within the judicial recess, a time during which they are short-staffed and have to deal with a competing priority to prepare for the defense case in the Thaçi et al. War crimes trial. The appeals panel on 28 July granted this request in part and extended the deadline for handing in the appeals from 4th to 18th August 2025. On 5th August, the pretrial judge ordered the continued detention of Hashim Thaçi, Izni Kilay, Bashkim Smakai, and Fadil Fazliou, assessing that there are continued risks that the accused may flee, obstruct the progress of proceedings, and/or commit further crimes. She was persuaded that no condition outside of the Specialist Chamber's detention facility would sufficiently mitigate these risks. In her decisions, the pretrial judge considered the pervasive climate of fear and intimidation in Kosovo against witnesses and potential witnesses of the Specialist Chambers, as well as the specific charges the accused are facing. The appeals panel on 7th August rejected an appeal by the Thaçi defense concerning a preliminary motion the pretrial judge had rejected. The Thaçi defense claimed that it was for the trial panel in the Thaçi et al. War crimes case to deal with the indictment on contempt of court charges and not for the pretrial judge. The appeals panel found the motion inadmissible, arguing that preliminary motions that are appealable only concern challenges to the jurisdiction of the Specialist Chambers or decisions on detention on remand. On 18th August, the pretrial judge granted and rejected, in part, a request by the prosecution to prohibit certain people from visiting Mr. Thaçi in the detention facility. The pretrial judge granted the request concerning specific individuals, finding that the measure is necessary given that the persons in question appear on the audio recordings made by the prosecution in 23, showing that Mr. Thaçi repeatedly revealed confidential information to his visitors. However, the pretrial judge rejected the request where it concerned the three of Mr. Thaçi's brothers. While the pretrial judge noted that the brothers discussed protected witnesses, including how one witness should testify and as such are likely to have participated in the disclosure of confidential information to third parties, she also recalled the importance of maintaining close relationships with family and accepted the defense submission that these three brothers provide Mr. Thaçi with invaluable moral support. The pretrial judge was mindful that contact with family is even more important, considering that Mr. Thaçi's father passed away recently. The pretrial judge highlighted that the restrictions ordered through her decision should only be maintained for as long as they serve a legitimate aim and continue to be necessary and proportionate. And she announced that she will review the necessity of these measures every 3 months. On 18th August, the pretrial judge rejected Mr. Thaçi's request to appeal her decision. Addressing the issues raised in the defense request, the judge made clear that she had assessed both the level of risk posed by each concerned visitor and whether the prohibition of visits by these individuals was necessary and proportionate in order to mitigate the risks of confidential information being unlawfully disclosed. She concluded that the issues Mr. Thaçi raised were not appealable and that the defense merely disagreed with her decision. In the case of Pieta Shala, the president of the Specialist Chambers, Judge Ekaterina Trendafilova, on 25th July assigned a Supreme Court panel to decide on the defense request for an extension of time and word limit for its request for protection of legality. Mr. Schaller had argued that due to the court recess causing staffing issues, and because the appeals judgment will only be available in Albanian language on 12 September, the additional time is needed to prepare for their request. The Supreme Court panel consists of judges Ekaterina Trandafilova, Christine van den Wijngaard, and Daniel Franzen. On 8 August, the Supreme Court panel dismissed Mr. Schaller's request, finding there was no legal basis to worry the time limit and that the defense did not show how the factors they refer to in their request would justify a large extension of the word limit. The panel noted that the appeal judgment was issued in English as the agreed working language of the proceedings, and that a request for protection of legality is entirely of a legal nature. As such, it falls within the responsibility of the defense counsel to advise their client concerning the request. On 25 July, a decision by the single judge from 8 May became public, which deals with the payment of reparations in the Salih Mustafa case. In the decision, the single judge ordered persons or institutions involved in the indigence assessment of Mr. Mustafa to comply with his previous orders and provide the necessary information to the registrar of the specialist chambers. The single judge further ordered the registrar to provide a comprehensive report on Mr. Mustafa's indigence by no later than 25 June 2025. The single judge underlined that a conclusion must be reached on this issue as soon as practicable for the registrar and victims' counsel to be in a position to seek compensation from the Kosovo Crime Victim Compensation Program should it become apparent that Mr. Mustafa's current assets would not allow a full enforcement of the reparations order within a reasonable time. On 11 August, the single judge granted Mr. Mustafa permission to appeal a decision from 16 July in which the judge had ordered Mr. Mustafa to pay 8% interest per year on the amount of the reparations that had not been paid yet. The single judge found that the issue affects the fair and expeditious conduct of the reparation proceedings and that a decision on this issue would materially advance reparation proceedings. On 14 August, Specialist Chambers President Ekaterina Trandafilova assigned a Court of Appeals panel to decide on this issue. The appeals panel consists of judges Michel Picard, Kai Ambos, and Nina Jorgensen. That was all from me. Thank you very much for joining. If there are any questions, I'm happy to respond.